once again, it's Damien Grant and Brent Norling, and we're here today talking about the obligation of various parties to provide information to companies once they go into liquidation. And one of the first things to remember is that when a company goes into liquidation, that company would have had relationships with various external parties, particularly from an insolvency perspective, the company's lawyer and the company's accountant. So those individuals were providing services to the company. And the fact that the company is in liquidation doesn't change the nature of that. We quite often face situations where we will ask a company director, the company's lawyer, for information, and the lawyer will say, no, the information is privileged, because sometimes in the lawyer's mind, the relationship is with the company director, not necessarily the company. Now, to be fair, sometimes there is separate advice given to the company director that's separate from the advice given to the company, but 19 times out of 20, the company is paying for those bills, and so that information should come through to that. So even before we get on to the statutory obligations in an insolvency situation, which we're going to talk about in a second, there are obligations of lawyers and accountants, but also potentially other professionals like banks and architects and so forth to provide information to a company once it goes to liquidation. But Brent, when a company is in liquidation, Parliament's given some particularly onerous obligations under Section 261 of the Act. So talk us through about that.
Yeah, so Section 261 is a pretty far-reaching section which allows liquidators to get a whole range of information from a whole range of people that may have knowledge of the affairs of the company. So anyone with knowledge of the affairs of the company could be subject to a request by a liquidator under Section 261. And so just broadly, the section is divided into two broad powers. So liquidators can get documents, or they can require individuals to attend an interview which is under oath. In relation to documents, they're documents of the company, which is different to, say, documents that relate to the company, which we'll come to. But so they're documents that are the company's documents.
So that's Section 261. Would that apply to, say, an employee?
Yes.
Right. Yep.
So employees, accountants, lawyers, bankers, anyone with those documents. So
what about a customer?
If it is a document of the company or they have information, yes, it can apply to a customer. But see, most customers, the information that they have is their own. So there's a classic example where a liquidator wanted all of the statements of accounts from a customer, and the customer said no, because the liquidator wanted it so they could preserve avoidable transactions. So quite rightly, they didn't want to give them.
Was that me?
No, but the specific one, no.
Okay.
But I'm sure there's probably some examples. And that liquidator couldn't get it under Section 261 because the statements of accounts were the customer's documents. They related to the company, but they were their documents. So
talk a bit about you said an interview. So talk us through about what that looks like. Yeah.
So a liquidator can interview a person who has knowledge on the affairs of the company. So practically, people are entitled to legal advice, are entitled to legal representation. At the interview, it's only limited to the affairs of the company. Most liquidators are quite opportunistic, and so they will quite naturally ask questions that don't relate to the affairs of the company, and good on them, good on them for trying. And a lot of time they actually get away with it because...
So just come at that. So that 261 interview, what's the nature of that interview? Is it under oath?
It is under oath.
And what's the consequence for not answering a question in that circumstance?
So at the interview, you can't refuse to answer a question. What if you don't know the answer?
What if it's a crime? What if you have committed fraud inside the company? Are you obligated to tell the liquidator about the fraud?
Yes.
That's outrageous.
So nothing you say at the interview can be used against that person in a criminal context, with one exception, and that's perjury.
So if you're a company director and you have committed fraud inside your company, you have to tell the liquidator about that.
No, you don't have to tell them, but if you get questions on the issue and it's relevant to the company, then there would be an obligation to answer.
But that confession, if you like, can't be used
if the individual lied, then that could be used in a perjury prosecution.
Right, gotcha.
And so what I see at most interviews with liquidators is, let's just say there's been transfers to related entities or transfers to the director. Quite commonly, the liquidator will want to know what's going on, so they'll ask questions about the new company. And for the kind of uninformed, they'll answer those questions because they don't know that they can refuse, but they can because it doesn't relate to the affairs of this company. It's a new company, they can say no. All they need to know is this part of the transaction going across. And so, it's
can a liquidator ask a company director or anybody in that situation about their personal financial affairs?
No.
Can they ask whether or not they have insurance to see whether or not they can sue them?
No. That's been tested at the Court of Appeal, unfortunately. And
very disappointing
and the
result.
Court of Appeal said no. And so yeah, it's usually directors that are being interviewed, and it's usually a fishing expedition. It's really important at these interviews that you don't guess, you don't answer a question unless you're 100% sure. So if you don't know, you say I don't know, or I need to refresh my memory, need to go look at these documents. And
so somebody in a 261, they're obviously entitled to bring a lawyer.
Absolutely.
Okay.
Yeah.
Right. And so let's move on to 266. So what specifically does 266 allow a liquidator to do?
So Section 266 is kind of the enforcement mechanism for Section 261. So if a party fails to comply with the liquidator's notice, then a liquidator can go to court requiring that person to comply, either give documents or attend an interview. But Section 266 actually gives the liquidator a wider ambit for documents. So 261 is limited to documents of the company. 266 says that liquidators can get documents that relate to the company. So a liquidator can practically go to people that have documents that relate to the company but may not be of the company, and gather that up. And it's designed because liquidators have very limited knowledge, as you know.
We're not always
specifically about the affairs of the company.
If we were smarter, we'd be accountants.
So
if we had people skills, we'd be lawyers. Okay, so just stay on that for a second. So Section 261 allows the liquidator to interview people under oath if they have knowledge of the affairs of the company, and allows them to get documents that are the company's documents. 266 will allow a liquidator to enforce their rights under 261, potentially, I understand, even interview a director or somebody in front of a judge, particularly onerous power. But under 266, a liquidator can ask for documents that are not the company's documents but relate to the company. But the protection there is that the judge must agree that the liquidator is entitled to that information.
Yeah.
Whereas under 261, it's an automatic right.
Yeah.
So tell us now a little bit about Section 274, because I know that's something you're quite interested in.
Yeah. So I suppose one thing that's quite commonly missed by directors of failed companies is the obligation under Section 274. So, 261, that requires a liquidator to be proactive and issue a notice, whereas Section 274 is an obligation of a director or an employee of the company that triggers immediately on a liquidation. So if you're a director or an employee of a company, you have an obligation forthwith after the liquidation to give all the information about the assets of the company, so where they are, and then the liquidator can then direct you to deliver them at a place that he or she wants them to be delivered. And so it's quite a serious obligation, not one that's commonly enforced, but the consequence of not complying is up to 2 years imprisonment or a $50,000 fine.
Come on, let's be real here though. I mean, we've been involved in a couple of cases, Misala in particular, where there were persistent, ongoing breaches, and indeed the Ranoff case as well, where there was, again, persistent, ongoing breaches, and the attitude of the court was what?
Yeah, I mean, it's pretty disappointing. Parliament has given these teeth in the legislation, and it's not used. it's not used anywhere near to the extent that it's there. So I mean, I would like to see some of these provisions enforced more vigorously, but the reality is they're not.
So, but in the Masala case, there was potentially millions of dollars of assets, allegedly, and the individuals involved just flat out refused to comply and got issued with, I think, a $20,000 fine, something really de minimis, and I'm not even sure they paid that in the end. So yeah, that element of the law is disappointing, and I don't think it's been covered under the changes to the regime. Right, so that's, I think, a quick summary of directors and other people's obligations to comply with the request for liquidators from information, and obviously you now represent people who are on the receiving end of requests.
Yeah, we see lots of confetti.
And we issue lots of it.
Yeah.
All right, thanks very much, guys. We'll see you next week.